Good afternoon, everyone. My name is Jeff Smith. I'm a partner here at Altitude Community Law. I'm also the head of our litigation department. We are going to be going over reasonable accommodations and modifications today. It is a lot of information to get through, so I'm going to try and hopefully get through it all in an hour. And if I end early, certainly try and answer some of your questions. Thank you for joining us today. On your screen, sorry, I got to do some housekeeping stuff. On your screen, you should primarily be seeing the PowerPoint presentation. You should additionally be seeing a small box on the left-hand side of the screen with the presenter, myself. On the right side of the menu, you'll see a private chat icon. Please use this icon to type in your questions throughout the presentation. Questions will be addressed at the end of the webinar, time permitting. If you have audio or video issues during the presentation, please click the no audio or video button below the PowerPoint on your screen and follow the instructions. One CMCA credit will be automatically generated and emailed to you within 48 hours after the webinar, assuming you attended the entire program. These credits are not transferable. As a reminder, this presentation will be recorded and added to Altitude YouTube channel within a couple of days. Lastly, there will be a survey that will pop up at the end of the webinar. We truly do appreciate your feedback, so any thoughts that you have, we will gladly receive. So first thing, this is a class about reasonable accommodations and modifications, what makes them reasonable. If there's two things for you to take away from this class, first thing is that what might be reasonable in one situation might not be reasonable in another. So if you have a board that is wanting to deny a reasonable accommodation or modification, please make sure you reach out to the association's counsel so they can review the facts and help you walk through the process with the board. And then the second thing is that when we are talking about these things, one of the things that the Colorado Civil Rights Division will look at to make sure that we are complying with federal law is, was there communication back and forth between the owner and the association? So we want to have that dialogue. We might want to be offering up different options for them, things along those lines. But the dialogue is huge. So those are the two things to really get out of this, is that everything is fact specific, and two, make sure we're having a dialogue with the owners. With that being said, let's dive into this. So there's also additional resources. As you guys all, I'm sure, are aware, our website has lots of different articles on it and blogs. You can find those in the education. You can search for it by a title. You can search for it by keyword, all of those things. We also do a lot of Facebook, Twitter, LinkedIn type stuff. So please make sure you subscribe to all of that so you can keep up to date on new legislation and anything that's happening in the industry. All right, so there are several statutes that can relate to discrimination. And so when we're talking about reasonable accommodations, reasonable modifications, we're talking about the Fair Housing Act mostly. Typically, we're talking about an individual who has a disability and they are needing some type of accommodation or modification to be able to use the property in the same way that an able-bodied individual would be able to use it. So the things that come up the most are the Civil Rights Act, the Civil Rights Amendment Act, or Act Amended, the Rehabilitation Act, the Fair Housing Amendment Act, that's the FHA, the ADA, which oftentimes gets confused by homeowners with the FHA, and then you have the Air Carrier Access Act, which doesn't really come up with us very often, but leads to some kind of interesting situations. So by statute, just talking about the Air Act, Air Carrier Act. I don't know when the last time you guys flew, but there are lots of animals that are coming on planes these days, and people are trying to get them on as support animals or service animals. And because of that, it's actually been fairly good. We've started to get there's been a little crackdown on that. And so some of those laws that are being applied there are also helping to guide us in the FHA realm. So it's been a little bit helpful to see some of those things. HOAs, as we talked about briefly, are typically going to fall under the Fair Housing Act. Occasionally, the ADA Act may apply if you have a portion of your property that is open to the public. So if you are downtown Denver, it's possible that your first floor might be shops or restaurants, and then the rest of the building is housing. So the ADA might apply or likely will apply on that first floor, but wouldn't apply on the residential floors. So that's where the ADA can come into effect. Sometimes it might come into effect too if you have a community pool that you have that's open to the public, not just the community. So those are times where they both might come into play. All right, so the ADA, touch on this first. The American with Disabilities Act prohibits discrimination and ensures equal opportunity for persons with disabilities in employment, state and local government services, public accommodations, commercial facilities, and transportation. Where we see it in the HOA realm or Metro District realm is with the public accommodations. So as we touched on briefly, maybe you have a clubhouse, maybe you have a pool. If those things are open to the public, they would likely need to be compliant with ADA requirements. So most of the time, ADA does not apply. As we said, ADA applies to places open to the public. Most HOAs are only open to its members and their guests. Anytime you think about renting the pool or clubhouse to non-members or classes to non-members, that could bring in the ADA. So if you were to try and rent out your pool to someone that did not live in the community, whether maybe it's a swim team, maybe it's something along those lines that's not made up of just community members, that might mean that your pool has to be ADA compliant. So if you're thinking about those things, make sure you reach out to your attorney and make sure that this is okay, that you don't need to pick up any additional insurance. There doesn't need to be changes to the pool to be ADA compliant, things along those lines. You don't want to rent it out and then deal with this on the back end because that can be an absolute nightmare. Colorado also has its own statute, the Colorado Civil Rights Act. It relates to housing practices. It will allow for actual damages, also allows for civil penalties. Civil penalties are something that your insurance won't pick up. Also allows for attorney's fees. All right, so the Fair Housing Act. The Fair Housing Act prohibits discrimination against protected classes. Those classes are race, creed, color, religion, sex, handicap/disability, familial status, marital status, national origin, ancestry, sexual orientation. You can see on this slide the ones that stay state only. That is because they are codified in our state statute. They are not federal. The other ones that don't say state only, those are all federal. So all of them would apply to the state, and then there are a few that would be federal only. The ones that we run into the most in the HOA industry are going to be those bolded topics. So religion, handicap, disability, familial status. Those are the ones that pop up the most in HOAs, especially obviously handicap, disability. Religion we don't see quite as often anymore. Familial status pops up a bunch when we're talking about pool rules or rules that are governing the common elements that might be specific to children. All right, types of discrimination. So refusal to accommodate a protected person. That's the most easiest way to decide it. You have discriminatory treatment. This is a provision in your documents that would discriminate on its face. So an example of discriminatory treatment might be a rule for adult only or children only. So maybe it's adult swim time only or something along those lines. We typically, if you're going to have a time set out where you don't want the pool to be used for games and things like that. If say you wanted to have a time where people could swim laps, you'd want to have a lap time as opposed to an adult swim. That way, whether they're 12 or 7 or 84, as long as they're swimming laps and they have the ability to swim laps, they'd all be in. So that way you're not discriminating against a set of people, just children. You are just designating the pool for that specific time to be used as a lap only time. Another way is disparate impact. That is something that is facially neutral, but has a discriminatory impact. So something like that might be a rule that says no noise rule that only applies to children screaming and playing outside. So if you have a rule that says quiet time between 4 and 6, while that might look on its face, so no yelling or no loud noises in the common area between 4 and 6, while on its face that might look like it's facially neutral. Typically those loud noises would be coming from children at 4 to 6 after school, before dinner. And so that might have a discriminatory impact on the children, even though it looks facially neutral. So that could still be a type of discrimination. Obviously, refusal to allow a modification to a property for a protected person. That's what we're basically talking about right now, both accommodations and modifications. And I apologize for talking fast, but there's a ton of slides to get through. All right, so how does this apply to homeowners associations? When an HOA has a covenant or rule which prevents a homeowner from using and enjoying their home because of one of the listed protected areas, and the HOA refuses to make a reasonable accommodation or modification, that's typically what we're going to be dealing with. So maybe it's an individual who is handicapped and you live in a condominium and they want a closer parking space. Maybe it's someone who has steps leading up to their house, but not needs a ramp because of a wheelchair, things along those lines. Those are things that we deal with all the time. Sometimes we get more specific type things. Maybe someone's allergic to pesticides or has a disability with pesticides, and so we need to make sure we give them additional notice. Things along those lines might come up. When the association fails to fairly and consistently apply its governing documents to all. So we get discrimination on those lines. So maybe we're treating one family different than another. We're treating someone of a different race differently than we're treating someone else. Those don't usually come up, even though we might get that allegation. It's pretty rare that a board is going to treat someone differently in our kind of general term of what is discrimination. You don't find all that many people publicly at least saying that they are going to treat someone differently just because of how they were born. All right, discriminatory-based harassment. So quid pro quo. This comes up all the time. The Fair Housing Act prohibits discrimination. Most of the time, the issue to the HOA is do not discriminate. However, we do have a case in October 2020. HUD, the Department of Housing and Urban Development, adopted some rules in 2016. They amended the Fair Housing Regulations to formalize standards for the investigation and adjudication of claims of violation for harassment based on race, color, religion, national origin, sex, familial status, or disability. So sometimes we'll have neighbors complaining about each other. Maybe it's just a noise complaint. Maybe someone built something. And in the past, we would always say that's just a neighbor-to-neighbor dispute. Association doesn't have to do anything. However, depending on what it is, if there is someone that is next door and they're saying, my neighbor is harassing me because of my race or my religion, the association probably needs to do some investigation in there to make sure that we've covered everything we can cover as an association under our governing documents. So these new rules were meant to address this quid pro quo, or this for that, harassment and hostile environment harassment. While these type of discriminations were already recognized as violations under the FHA, they were not specifically addressed or defined. Instead, these violations were investigated and examined according to those standards established for employment discrimination. So the key thing from this is that community associations, the new rules describe how the principles of direct and vicarious liability shall apply in the context of a fair housing violation, to provide that a community associations, its board members, its managing agent can be held liable for the discrimination of others under the FHA, even if they were not directly involved in the conduct. Fair Housing Act requires association to take all steps that they can take to stop the discrimination. Now, in a homeowners association, most likely the only thing we're going to be able to do is send a letter to that neighbor, and probably we're going to send it to both of them, because when this usually happens, both sides are saying the other side is harassing me. And if they bring up something that would be covered under the FHA, we would basically send a letter to both owners saying, look, this might be a nuisance, this might be something under the governing documents, but you need to stop it. Because of the new laws in Colorado regarding how we can enforce covenants, there's not a whole lot more that we can do other than that courtesy notice, because more than likely whatever the action that's taking place is going to end as soon as the conversation stops between the two owners. But it is something that, to cover the association, oftentimes we will advise the association to send out a courtesy letter to both sides telling them basically to knock it off. All right, familial discrimination. So familial discrimination is based on family status. unequal treatment of children under 18, unequal treatment of pregnant women, unequal treatment of families based on size or content. So again, think about pool rules, no adult only swim times. Think about a rule where kids cannot play. So maybe it's a no skateboarding or no playing in the common areas. Maybe you have rules that are talking about how many people can rent a unit. Do they have to be related? All of those end up violating familial discrimination. Only HOPA communities, those age restricted communities, can prohibit children. So unless you're set up as a HOPA community, and if you don't know what a HOPA community is, then you're not set up as a HOPA community. Those are the only types of communities that can restrict based on age. Many times HOAs will try to stop group homes, whether that's a group home with children, whether that is a alcohol recovery or drug recovery home. HOAs tried to stop them. Unfortunately, you cannot prohibit those types of homes from coming into your communities. It's something that pops up at least once a year for a community that we represent. Sometimes it will pop up 4 or 5 times, depending on where we are in the economy. It's been a couple years since I've seen a big increase or had a huge influx of these kind of group homes, but they are always out there. When they come in, the association gets fired up, and unfortunately, we have to tell the association that we can't do anything because they're protected under the Fair Housing Act. Occupancy standards is another thing that comes up a lot. Oftentimes you might see, it comes up 2 different kinds of ways. So in most declarations, you'll see reference to single family homes and board members oftentimes take that to mean that only a single family can live in there. They have to be blood related or something along those lines. That's not the case. When we're talking about the requirements in a declaration that say single family homes, that's talking about the structure itself, not who's occupying it inside. So if someone were to try and turn a single family home into a duplex, that would be a violation of the covenants. But the fact that there might be multiple families or multiple generations or things along those lines living in the home, that does not violate that single family. Same thing with occupancy requirements. Typically, if you have concerns over occupancy requirements, you should direct that to your local municipality. They might have a better ability to enforce that under health and safety, as opposed to us, who we don't have those same abilities to control. So if take my family, if you had a community that said you can't have more than 5 people living in a home, I'm a family of 6. The likelihood that you'd be able to enforce that is almost impossible. If you can't enforce it against me, even though I have 4 kids, I have a wife, etc., the fact that instead of 2 adults and 4 kids, that it's 6 adults, it doesn't change the concept. Ultimately, those occupancy requirements are not going to be able to be enforced by the association. All right, religious discrimination. So there's no duty to accommodate religions. However, there is a duty to treat all religions the same and remain neutral with all rules so they don't discriminate against religions. So example, a clubhouse may not be used for any religious activities. The only permitted holiday decorations are Christmas lights. Ultimately, what we're saying is you can't allow, if you're going to allow a Catholic Bible study to take place in the clubhouse, then you'd have to allow a Jewish study of the Torah to allow there, or any of those things. You can't discriminate based on what type of religion it is. Either we're going to allow them all, or we're not going to allow any of them to take place in there. Likewise, if we're going to allow holiday decorations, but the only ones that we're going to allow are Christmas lights, that's going to violate the FHA as well, because again, you're singling out one group of people, saying they can do something and not allowing other people to do it. I mean, these are kind of self-explanatory types things. Typically, when we're dealing with things that are more nuanced, we did have a legislative change. It's probably been 7 or 8 years ago now, where one of the state legislators had a mom who was living in a condominium unit. The mom would hang a Jewish religious symbol on the door. The HOA had a rule saying you can't hang anything on the door. It was because it was done for religious purposes. They still asked her to take it down. Because of that, the state changed the law to now allow specific religious symbols to be able to be hung on the door. We've also had times where you had people burning prayers in their yard, and religious discrimination has come up in terms of that. So these things do pop up, but I've not seen a whole lot of religious discrimination in probably the last 5 or 6 years. Next one is disability requests for reasonable accommodation or modification. First, we need to determine whether an individual has a disability, what the requested accommodation is and is it necessary to afford equal opportunity to use or enjoy the premises, and is the requested accommodation reasonable? So it's important what you can ask and what you cannot ask about a disability. Who has to answer the questions has also come up, and the HOA cannot require a doctor to answer the questions. It just needs to be a medical professional, or they've even expanded a little bit more that someone who might be reliable that would be able to know it. So your spouse might be able to answer the questions depending on what the disability is. Information that can be sought is verification that person making the request is disabled. You can ask how the requested accommodation or modification is needed to assist the homeowner in relation to disability. So if I have a disability that is something along the lines of PTSD, but what I'm asking for an accommodation is a wheelchair accessible ramp, those two don't match up. Although I might be disabled because I have PTSD, that doesn't have any nexus to the reasonable accommodation or modification of a wheelchair ramp. Now, if I'm in a wheelchair and I need a wheelchair ramp, obviously there's a nexus between my disability and what the accommodation or modification is that I'm requesting. All right, what can be asked about a service dog in a public place? So service dogs in public place, this is where an ADA would apply. One is the dog a service animal. Is this a service animal required by disability, because of a disability? And what work or tasks has the dog been trained to perform? So different than a emotional support animal, a service dog, and service animals can only be dogs or miniature ponies. A service dog is trained for a specific task. So maybe it's to warn me of a oncoming seizure, maybe it's to get medicine if something's going wrong, something along those lines. So these animals are specifically trained. They're trained for a task, and we can ask for verification to make sure that that is what is taking place to allow it. Again, owners frequently incorrectly make demands for compliance with ADA and comment about ADA limitations when in fact what we're dealing with is the FHA. Again, more than likely, when someone's talking about ADA, they're really talking about the FHA. And honestly, we don't really ever have any problems with service animals. Again, service animals are trained. They are well behaved. They're generally sitting right next to their owner. They're very attentive to their owner. They don't care a whole lot about what's going on outside of their owner because they're there to perform a task. Where we run into issues is those emotional support animals. All right, so under the FHA, what can be requested? Number one, reliable documentation of a disability. 2, what accommodation they need. And 3, how does the accommodation relate to their disability? Those are the only questions we get to ask. You can only ask for documentation of a disability if the disability is not visible. So you can't ask for documentation from someone in a wheelchair or a blind person. Someone that has a visible disability and they're requesting a accommodation related to that disability, we're not going to be able to ask for verification of the disability because we can readily see it. It's readily apparent. All right, disability definition. Physical or mental impairment which substantially limits one or more major life activity. A record of having such an impairment or being regarded as having such an impairment. So major life activities. Caring for oneself, performing manual tasks, walking, seeing, hearing, breathing, learning, working. Eating is also included, although it's included under the ADA. So disability is not what you or Webster thinks a disability is. Disability has a clearly defined term under the FHA. You could have a disability because of severe allergies. We've had that come up in terms of carpet. There's all sorts of things that can qualify as a disability that are outside of what we normally think a disability is. Ultimately, it's just a matter of whether it affects one of their major life activities or not. All right, being regarded as having a disability. A covered entity mistakenly believes that a person has a physical impairment that substantially limits one or more major life activities, or a covered entity mistakenly believes that an actual non-limiting impairment substantially limits one or more major life activities. These ones don't come up in the HOA world very often. Typically, as you guys are aware, when someone has a disability or is claiming a disability, they are going to make it readily apparent to the board what that is. They're going to tell you, they're going to say, look, I have XYZ. Maybe I have mobility impairment, something along those lines. They're going to ask for the accommodation. If we can't see the mobility impairment, we're going to ask for additional information. It's pretty rare that we come across a case where someone says that we regarded that individual as having a disability without them telling us. Again, handicap disabilities, vast range, could be orthopedic, hearing, mobility, speech and visual, CP, autism, epilepsy. You can read this whole list, but there's a huge range of what can be considered a disability. The range is limited by the fact that the disability must substantially limit one or more life activities. The word substantial precludes impairments that interfere in only a minor way with major life activities. Also, it must be permanent. A temporary impairment does not meet the statutory definition. So if I'm having hip replacement surgery and I request a reasonable accommodation or modification, that is not a disability as defined under the FHA. So the association would not have to make a reasonable accommodation for that. So if I only needed a closer parking spot for 3 months because of this, because of my hip replacement, the association would not have to accommodate that. Just because the association doesn't have to accommodate it, though, doesn't mean that the association can't. So it's not that we have to be bad neighbors or anything along those lines. If we have the ability to make an accommodation, we might want to, but we're not required to under law for those temporary disabilities or temporary impairments. The law not only applies to the disabled person, but persons associated with them. Also applies to those recovering from substance abuse addictions, but not to current users. So that second one, that recovering from, that's how you get the group homes for alcohol treatment or drug treatment. In terms of the law, not only applies to the disabled person, but those next to them. Title 8 extends to handicap of buyer or renter, any person who will reside in the unit, and any person associated with the buyer or renter. Does not, so ultimately what that's saying is if I buy a house and my mom is in a wheelchair and she comes over, she's going to come over to visit me, and in order able for her to get into the house, I request that a wheelchair ramp be put in so that it's easier for her to get in or out. The association would probably still have to grant that so that my mother can get into the house to visit me. That's where the additional people come in most often. All right, FHA documentation. So what is reliable? Doctor recommendation, medical records versus a note, other forms. So we cannot refuse because someone submits something to us that's not on the form that we like. We like to provide them with forms. We always recommend that an association have a reasonable accommodation, reasonable modification policy. And typically with that, there will be a form that they can give to their medical provider, and the medical provider can fill it out. But they don't have to use our form. They can provide us with the information any way that they deem fit. We have to take it. So if they send it to us in an email, if it's just a written note, any of those things, that is all fine, as long as the association can tell from whatever they've been provided that the disability is there. Evaluating requests for accommodations. What's reliable documentation? So when we're talking about emotional support animals or service animals, especially, oftentimes people pull things off the internet. So some websites will sell certificates, registrations, license documents for assistance animals to anyone who answers certain questions or participates in a short interview and pays a fee. Under the FHA, a housing provider may request reliable documentation when an individual requesting a reasonable accommodation has a disability and disability-related need for an accommodation that are not obvious or otherwise known. In HUD's experience, such documentation from the internet is not by itself sufficient to reliably establish that an individual has a non-observable disability or disability-related need for an assistant animal. So ultimately, if someone just comes to us and gives us our that online document says this is a registered ESA, great. We don't, not that we don't care, but that in and of itself doesn't mean we have to allow that animal. Now, if they give us that certificate along with a letter from a doctor saying that this individual has PTSD or is somehow otherwise disabled under the Fair Housing Act, then we would need to provide the accommodation. Most legitimate licensed healthcare professionals deliver services remotely, so just the fact that it's coming over the internet does not mean that that's not reliable. But as long as we get something from the healthcare professional showing that they are treating this individual, the individual is disabled as defined by the FHA, and here's what they need, that's what we're going to be looking for. But simply a certificate about an animal is not going to carry enough weight. One other thing that is helpful, I would say, for all managers and really anyone, is the HUD has, Housing and Urban Development has set out all of these different kind of practice pointers, guidelines, etc. If you search the HUD website and you put emotional support animal or reasonable accommodation, you will find these. Usually they're about 8 to 16 pages, and they give you kind of the outline of what is allowed, what isn't allowed, what questions can you ask, etc. It's a great little thing to have filed away when someone's bringing up a reasonable accommodation request. It gives you examples. It can sometimes will point out who has to pay for what, etc. So it's good. It's a very helpful resource for you. Obviously, you can contact your attorneys, and you should anytime you're getting a reasonable accommodation, but just for general understanding, they are very helpful. As we were just talking about these United States Service Dog Registry, service dogs don't need to be registered. All they have to do is be trained. This letter does nothing for us in terms of proving that there is a disability or that they need to have this dog. There is no National Service Dog Registry. All right, evaluating requests for accommodations. What if there's a request for multiple assistance animals? So first thing we're going to look at, is it a service animal or an ESA? If we're talking about a service animal, then each service animal must perform a different task. So if we have a rule that says you can't have any animals, this individual moves in and says, I have 2 service animals, they would have to show that each service animal is trained to perform a different task related to the individual's disability. In terms of an ESA, again, there are no training for that. So we've had some success with limiting the amount of ESAs an individual can have. We try to point to it that they need to have medical documentation for the multiple ESAs. It should discuss a disability-related need for each ESA and not just list the ESAs. The CCRD here in Colorado is very liberal and very pro-owner. And so as you can, they've had battles with the Supreme Court with the cake case. I mean, there's lots of things that have gone on. The law should say that they need to have those things. The CCRD does not always believe that. Sometimes we get them to side with us saying, yes, you need to show that each ESA needs to be serving its own individual purpose. Sometimes they come down and say, no, the doctor said they needed all 4 of those, and that's what they needed. So those can be pretty tricky when they're trying to claim multiple ESAs. Oftentimes that'll happen in a community where you have a 2-animal limit, and they might have 3 dogs, and they claim that this 3rd dog is an ESA. Or maybe they have 4 dogs and they're claiming 2 of them are ESAs. That can come up, and that is a problematic situation that you're going to want to talk through with the attorney, walk through the specific facts, see what we can have so the attorney can advise the association what is the best course of action based on these specific facts. All right, evaluating requests. So you can't charge a fee, a licensing charge, or a deposit when you're dealing with a reasonable accommodation. So if someone wants to have a dog and you're one of those communities that charges a fee to have a dog, you can't charge that fee if the dog is an ESA. You can't pass on costs of attorney's fees and advice regarding the reasonable accommodation request. That's something the association just has to eat. If you do pass it on, you're opening the association up for a possible CCRD retaliation complaint. So we don't want to put any of those attorney's fees on there. We can require that they comply with normal pet restrictions, even though they're not a pet. So if they can't leave poop out on the common elements or in their yard, they have to pick up after their animal. If there is a leash requirement, they can be required to be on a leash unless they are a service animal that would they're trained for something else. So if they can't be on a leash because they're trained to go get help if you have a seizure or something along those lines, we can't require a leash in those terms. But if it's just simply an ESA, we can still keep those leash laws in place or those leash rules in place. Pets are allowed because the courts have held that it's not unreasonable to allow a pet into a residence. There are exceptions. If a dog is violent, it is no longer a reasonable request, and the association may demand its removal. So if the ESA becomes has bit another dog or maybe bites a person, that would be grounds for us to remove it. Or if it has done that in the past, that would be grounds for us not to grant the accommodation. You can't deny it just because of the breed. That would be problematic. There has to be violent action to demand the removal. Otherwise, the animal may be required to follow normal pet rules. Like we said, things along the lines of on leash, no excessive barking, no jumping on people, all of those things. If an owner violates those rules, then we would have the ability to demand the removal, even if it is an emotional support animal. Again, if we're talking about that, though, if it jumped on one person or it barked a couple times, like we're going to need to see excessive actions before we would demand removal. So some practice pointers. The applicant for a request is not required to be an owner or the person in need of the accommodation or modification. We touched on that briefly earlier. Do not request medical information if the disability is obvious and it is obvious how the requested modification will contribute to use and enjoyment. The healthcare provider is not required to be a physician. A medical professional is fine. You want to respond to requests in writing in a timely manner. Courts have held delay is the same as a constructive denial. So if you get a request in for this and your board doesn't meet for 3 months and you don't make a decision for 3 months, courts have held that might be constructive denial and the association could be liable. So you want to, anytime you get a reasonable accommodation request, you want to get that to the board as quickly as possible, and then you want to get that to the attorneys as quickly as possible. The longer the delay, the bigger the problem. If there is no request, there's generally no obligation to make the accommodation. However, if a verbal request is made, you should follow through. Also, if an accommodation is obvious, offer it. So in terms of the verbal request, if someone comes to a board meeting and says, I would like to put in a ramp because of my mom's being in a wheelchair, whatever it is, and that's where they leave it at, you should follow up with them in writing and say, look, you came to the board meeting, we appreciate it. You said that you'd like to put in a board ramp. Can you please submit to the ARC what you're planning to do so that we can evaluate this? And if you're requesting this as a reasonable accommodation, can you please provide us with the documentation that we need to review that? So that is big. Obviously, if someone comes in the same way, if someone comes in the wheelchair to the meeting and says, look, I want to put in a ramp for my house, it still would be proper to ask them to go through the ARC process, but they probably don't need to put in that same information of the doctor's note, things along those lines, because it's readily available. It's readily apparent that they are disabled, they're in a wheelchair, they need this ramp. Courts have not allowed associations to hide behind technicalities. So if an oral request is made, respond, even if the response is simply to ask them to place the request in writing and then act upon that, obviously. And there's no magic words in this. They don't have to say I'm requesting an accommodation. They just need to let you know, look, I'm requesting this because I have mobility issues and this is why I need it. You don't need to use any specific words to trigger the Fair Housing Act. Do not deny a request because of a related or unrelated violation at the time of the request. So oftentimes what will happen, new owner moves in, say it's a no pet place, they have a dog, we find them for having a dog, or we send the letter, then we find them. Then they reach out to us and say, no, this is actually an ESA. In the past, we have had boards refuse to determine whether it's an ESA or not until the owner pays the fines. You don't want to do that. That'll get you into lots of trouble. You're going to want to place all violation issues about request on hold while the applicant obtains the requested information, or advise that the fines will be removed if they are found. They're found so that to show that the animal is actually needed pursuant to the FHA. Applicants will not generally be liable for the cost of any approved accommodation. Modifications are a little bit different, but with an accommodation is just to a rule. So there should not be any charges tied to that. And if there are any costs, typically that's not going to be the homeowner's responsibility. So again, you can't advise when you get in compliance and cannot advise when you get in compliance and current with dues will evaluate your request. If other open issues are there, put those on hold until we can deal with whatever's going on with the ESA. We don't want to be accused of retaliation. So if they have something that has nothing to do with this, but we haven't ruled and we're still finding them because they have weeds, they could try and come back to the CCRD and say, look, you're treating me, you're discriminating against me, you're using these fines as retaliation because I'm trying to get an emotional support animal. I'm needing this accommodation. If you send a violation notice for a dog and the owner after the fact then says it's an ESA, you don't have to stop the fine process, but you do have to make it clear that if the dog is found to be an ESA, the fines will be waived. So if they just simply say, look, this is an ESA and don't provide any documents, you'd continue with your process. If they say, no, this is an ESA, you ask them for documents and then they provide the documents, you're going to want to waive any fines that have been placed on there. So service animals and emotional support animals, I know there's a lot about this in here. It's simply because this is where most of our stuff comes up. Neither are pets per court. The ADA service animal is trained. Service animals are allowed in restaurants and other public places. ESAs are not. Service animals are defined by Title II and Title III of the ADA. Again, it's only dogs or miniature horses. You want to make sure that any rules you have are applying to animals, not pets. It's a better way to help us when we're trying to say all animals have to be on a leash as opposed to all pets, or all animals have to be fenced in behind the yard instead of pets. Because again, ESAs and service animals aren't pets, although they are still animals. So sometimes it's the language of the rules that are key to us to help us trying to keep the community the way that the community wants it to be, even though we might have to allow animals or more animals than they want or larger animals than they want, etc. Colorado does have a special twist to it. Service animals under the federal statute that are in training are not considered service animals. However, under Colorado law, a service animal in training is still going to be a service animal. So an animal that is being trained as a service animal and a trainer of a service animal are entitled to accommodations. So if you live in a community where one of the owners is training animals to be service animals, so training dogs to be service animals or miniature ponies, you would have to make accommodations for them, even though the trainer is not disabled. Reasonable modifications. So modification is going to be a physical change. They're going to follow the same process as accommodations. We need to know, is the individual disabled? Do we know what they are seeking? Can you make them submit plans and obtain approval? Cost is on owner when they're seeking modifications. So sometimes the modification is on HOA property. Sometimes it's on the owner's property. You can make sure it's aesthetically pleasing and well built. If what they want will cost the association a huge sum of money in the future, that may be grounds to say no. If on HOA property, you can require bonded insured workers on the property. So sometimes you might see this in a 3-story building that doesn't have an elevator. It has steps. Maybe they need to put in one of those chairs that will ride up the steps. And so it's going all over common elements to be able to get the person up to the 3rd floor or whatever it is. If the owner wants to put that in, they would more than likely have to pay for that cost themselves. If other people other than the owner are able to use it, that might change the decision making as to whether or not it's the owner who has to do it or not, has to pay for it. You also sometimes see this with wheelchair ramps. Maybe it's going to go over association property first before it gets to like a townhome or something along those lines, before it gets to the front door, things like that. But typically a modification is going to be paid for by the owner. One thing that there's a somewhat dispute as to whether or not like a curb cut. So if someone needs a handicapped parking space, most of the courts have ruled that a curb cut is really an accommodation, not a modification. So the association would have to pay for that. But typically when you're dealing with modifications, it's going to be on the homeowner's expense. Must make reasonable modification to allow full use in premises. It's deemed reasonable if it does not result in an undue financial and administrative burden or fundamentally alter the nature of the housing in question. So when we're talking about these kinds of issues, if we're trying to deny something, so undue financial and administrative burden. Maybe someone is housebound and they ask for a reasonable accommodation for the association to pay for a driver to come pick them up to take them to the grocery store so they can get groceries. That is going to be not something that we have to approve. One, it's going to have an undue financial burden because the association isn't set up to pay that. Additionally, it fundamentally alters the nature of the housing. We aren't there to provide groceries to people. We aren't there to pick up their dog's poop, etc. Those things that are outside of what we are set up to do, that might be a reason that we could deny a reasonable accommodation or modification. So what are we seeing when owners do not get what they want? So when an owner doesn't get what they want, the first thing that they're going to do typically is a CCRD action. That's the Colorado Civil Rights Division. Next thing that you might see is a lawsuit in either state or federal court. Potential outcomes could be fines against the association. It could be damages. There's all sorts of things that could happen if the association doesn't prevail. So what can the association really do? So the enforcer of this, when we're talking about reasonable accommodations, reasonable modifications, is the United States Department of Housing and Urban Development, HUD. Their mission is to ensure the access of every American to a decent, safe, and sanitary home and suitable living environment. You also have the CCRD and the CCRC. The CCRD is the enforcement arm of the CCRC, and HUD has certified the CCRD as a substantially equivalent agency. So ultimately, HUD typically will say, CCRD, you handle these issues in Colorado on our behalf. Sometimes HUD will keep them, but it's pretty rare. Typically, they'll all go to CCRD. So who is the CCRD? They're a government agency that enforces Colorado's anti-discrimination law. They work with the EEOC, so the Equal Employment, and they also work with Housing and Urban Development. They investigate claims of alleged discrimination. The CCRD and CCRC conduct hearings on character, causes, and extent of illegal discriminatory practices throughout Colorado. They advise the governor and General Assembly on policies and legislation, review appeals of cases investigated and dismissed by the CRC. They adopt and amend rules and regulations in the enforcement of the state discrimination statutes. So with the CCRD complaint, the reason why this happens first is because it's filed free of charge. So ultimately, the owner goes to the CCRD, they file a complaint saying XYZ HOA has discriminated against me. They provide a summary of what has been done, and then the CCRD will create a charge. So that charge is the housing complaint. They have to be filed within 1 year from the date of the last occurrence of the discriminatory act. The CCRD drafts the charge and they'll serve it on the association. Oftentimes they will name the management company and possibly the individual manager as well. Sometimes they'll name board members. The respondent, so the association is then given a chance to respond and provide information. Dispute resolution is highly recommended. There's an investigation. The division director will then make the determination. If the director finds against the association, then a conciliation will typically take place. And that's similar to a mediation, except everything is against the association. So basically it's a heavy-handed mediation where the CCRD is trying to get the association to do whatever it wants it to do. If the association is found against, then the association does have the right to appeal. Same thing if if it's found in favor of the association, the owner could appeal or just move to a federal lawsuit. The CCRD is, some people in my firm would say that they're biased. They are certainly very pro-owner, pro-disability. So we don't want to be in front of the CCRD all that often. I'll tell you, typically, if any of you guys have had CCRD issues, 95% of them, probably higher, probably 98%, we are able to get dismissed at this charging stage, but you're not able to charge those attorney's fees that you spent back to the owner. So it is a cost to the association, even if we win. On the request of information, you have a short turnaround. So when you get this letter from the CCRD, you only have 10 days to respond. So you need to get that to your attorney as quick as possible. We will always request an extension. They're usually pretty good about giving us a 2 to 3 week extension because there's a lot of information that we have to gather. We have to get all the governing documents, resolutions, correspondence, meeting minutes, violation logs, sometimes homeowner lists, if there's been a prior accommodation request, if there's been discrimination claims, photos, affidavits. There's a lot that the manager has to do in order for us to fill out our response. So it is very, it is time consuming, and it's a fire drill for us as attorneys during that short time frame to try and get this all in. So following the review, after the CCRD receives the information, again, it can request additional information should that be necessary. Oftentimes what the CCRD will like to do is they might want to do an interview. They may interview the owner, they may interview a manager, a board member, things like that. After that, the CCRD will issue a finding of either probable cause or no probable cause. What we want is no probable cause. That is meaning that the CCR does not believe that a violation of the FHA has taken place. If that's the case, from our standpoint, it's typically done. It's pretty rare that an owner will file a matter in state or federal court after the CCRD has found no probable cause, but we do have a case right now going on that is the case. So it does happen, but it's pretty uncommon. If probable cause is found, the next step would be we go to conciliation. If we aren't able to resolve in conciliation, then we would go to the CCRC, and there would be a hearing, and the CCRC panel would determine whether or not the association was in violation. If they find that we were, we can still appeal that. But typically, if you've been found for probable cause, your attorneys are going to tell you we need to figure out a way of conciliation to make this go away. The other option that an owner could do is they could go to the courts. They could skip the CCRD entirely, or after using the CCRD, they could then file a federal or state court. Because the FHA and FHAA are federal law, this case is typically going to be in federal court. So that is a extremely expensive endeavor where you might have a $10,000 to $15,000 state court case. You're talking more likely hundreds to $100 to a couple $100,000 if they are filing in federal court. Federal court is extremely expensive because of all the procedures that are involved there. Consequences, if you lose, there's a high cost, anywhere from $1 to $1 million. I mean, we've had cases that have had to get settled for right around $1 million for things such as not allowing a service animal in a home. So like they come with big ticket. This isn't your someone isn't pulling their weeds kind of case. These have big dollar amounts to them. So that's why we are so adamant that you get this to your attorney as quickly as possible. Even if you win, you lose. So even if we go through all this, we win. You're not going to be able to get your attorney's fees back. So cost of hiring legal counsel, that's going to be gone. There's time and aggravation. There's the public relations nightmare. All of these things are bad for the association, obviously. So the reason why we're talking about some of these preventative steps in terms of make sure you're working with the owners, have a reasonable accommodation, reasonable modification processes. We want you to solve this issue before it ever gets to a lawsuit or the CCRD. Because once it gets there, it's just an expense to the association. So prevention. Make sure you have legal counsel review your governing documents for discriminatory language and revise appropriately. Adopt a policy for all reasonable accommodation and modification requests. Make sure you take a cooperative versus defensive stance. Make sure you're keeping good records for all covenant violations, rule enforcement actions, and requests for architectural approval. Oftentimes what happens is someone gets denied for something. They say that they're denied because they're a protected class, even though that's not the reason why we denied them. But if we don't have the backup document to show that we also denied these 6 other people for this same request, that makes it much more difficult for us to prove that we are acting prudently. Make sure you're being consistent in the application of policies. Document in writing all communications and decisions. Make sure you're being sensitive to those to requests made by protected classes, those classes that we talked about at the very beginning of this slideshow. Become educated as to fair housing requirements. That's why you guys are all here, so that is good. You might want to print out the slideshow just so you have a lot of good information. Again, pull those HUD statements. They are very helpful. Some practice appointments. If you are going to deny, first make sure you talk to the attorney. Then document the denials thoroughly. Remember that the law allows disabled persons to enjoy their homes to the same extent as those without disabilities. I mean, overarching, make sure you're being reasonable. Always try and be as reasonable as possible. Where we get into the biggest issues is where there's been an underlying issue and maybe the board has had problems with this owner for years that have nothing to do with this, and now this individual comes in and is requesting accommodation, and so we have a bitter taste in our mouth, and we might treat them slightly differently than the person who comes who we've had a great relationship with. So we want to try and take that out and be as reasonable as possible. So just a couple brief things. Breed of dog we talked about briefly, but yeah, you can't prohibit the breed of dog or the weight of the dog, even if you have those requirements in your declaration. Again, cleaning up of dog waste, they are required to clean those things up. Sorry, we only have like 4 minutes, so trying to get through these. Common area access leashing, we talked about that. Can't prohibit service animals from the common areas. We can require animals to be on leashes unless they're whatever they are there to do would require them to be off leash. Again, delaying granting accommodations. This is a constructive denial of the request, and that's a bad thing. Get these dealt with as quick as possible. We talked about the nexus a lot. Again, there has to be a nexus between what the accommodation or modification is to their disability. Specialized training is what we're talking about with service animals, not support animals. Competing disabilities. So this comes up often. Someone comes in and says, I need this dog for whatever the reason is. Then their next door neighbor says, I'm allergic to dogs. Therefore, you can't allow this dog to be here. Ultimately, it's a first in time. So if that person who first requested the animal made the request for the accommodation before the person who then says that they're allergic to them, typically the courts are going to side with whoever came first in time. So that initial person who requested the animal is likely to win. Other animals, again, ESAs don't have to be dogs. We've seen cats, chickens, ducks, turtles, all sorts of different animals. People have snakes. All of these things have been used as ESAs. And again, as long as they get a letter from a medical professional saying they need this specific animal, it's going to qualify. Difference again, service animals have to be trained and they have to be a dog or a miniature horse or pony. Okay, 2 minutes left. Let me try and get through a couple of your questions. As an association board of directors on sound legal ground, developing a written rule and posting 7 of its 10 parking spaces for guest parking, and as a reasonable accommodation, posting 3 of its 10 townhome units with historically and currently parked pickup trucks in the association park that cannot otherwise be housed. So ultimately, it sounds like there's 10 parking spots. 7 have been designated as guest parking. There's 3 others. These parking spaces cannot otherwise be housed in tiny. So this, Mr. Crouch, I'm not exactly sure if I understand what you're saying, but ultimately, guest parking is not necessarily a reasonable accommodation. So if someone comes and they say, I need one of those guest parking spots to be used by me because I have a mobility disability, and one of these guest parking spots is closer than where my actual assigned parking spot is, we might have to grant an accommodation for that. But simply just having 10 parking spaces that some are for guest parking and 3 are posted as reasonable accommodation. Reasonable accommodation is directed to a specific individual or unit. It's not like an overarching thing. It's not a handicap space. So just having that, I don't think the way you described it would qualify. Our association is said to be ADA ready, and we have been told that our sidewalk slopes need to comply with ADA. I have a question if this is true. So, Mr. Fluke, I mean, ultimately, I'd have to see everything that you're talking about. More than likely, you don't have to be ADA compliant, but there may be some specific provision in your documents that would require it. Next question. regards to, can you please restate on adult hours allowed or not, 9 to 10 p.m. So I would never call something adult hours. I would call it lap swim or something along those lines. But anytime you start referring to adult, you run into the possibility of discriminating against children, familial discrimination. So I would not use the word adult. If you have a rule like that, I would suggest that you talk to your attorney, have them look at that and see if there's a better way to word it to get to a similar result without running afoul of the discrimination laws. Why is the association role to interject in a discrimination claim between neighbors? It's a good question. I don't know why it's their role. More than likely, we're not going to be able to do anything to actually stop it. But what we want to do is protect the association and make sure that we send something to the owners, to the offending owners that say, look, we've received complaints. Here's what it is. We believe this is a violation of the governing documents. And then more than likely, that's it. But again, you're going to want to talk to your attorneys about that to see what is the best steps. But more than likely, we're not going to be able to stop it. We just want to make sure that we have documentation showing that we've addressed it in some manner. Can an HOA short-term rental guests considered members of the public? Short-term rental guests would not, someone having a short-term rental would not bring you into the ADA by itself, I believe is your question, Mr. Greenhouse. Just because they have short-term renters, that wouldn't make it a place of public accommodation. Can you please? You have a question about whether short-term and long-term rentals, if there's a difference between whether or not ESAs can be allowed. I'm not aware of any difference. I don't believe that there is a distinction between the two as to whether you can allow or disallow the ESA. Can an HOA legally create a policy that only owners can have pets? I would not recommend creating any type of policy that would divide groups of people up, whether that's owners or anyone else. You don't want to be treating people differently. Is it possible that you could do an owners only pets only? You probably could, but I think you'd have an almost impossible time trying to enforce it. So I would not recommend doing something like that. Owner's adult son lived with her and was in a wheelchair. She wanted an entry door converted to an automatic door. HOA said okay, but she had to cover the cost. Should HOA have paid? So on a specific question like this, as to who has to pay for a modification, we'd have to see all of the facts. But to answer your question, Ms. Compton, the general rule is that for a modification is the owner who would have to pay for it, not the association. That could change, but you'd want to run that by your actual attorney. 55 plus communities are allowed to have adult only time. That's because they are age restricted communities, so they are not subject to those same restrictions. I have a homeowner wanting to install a privacy fence, not allowed where they live because she has 3 little dogs and she's unable to walk. She's worried they'll get out of her yard and she won't be able to go after them. She's allowed split rail fencing and can install chicken wire. Does this qualify as something I would have to approve? Again, if you have a reasonable one, if she's disabled, we'd have to look at it. If she's making a reasonable accommodation request, again, I wouldn't make that decision on your own. I would get that to the attorney. Without knowing any of the facts and just looking at what you're saying, Ms. Myers, I would say a split rail fence with chicken wire is probably fine. She probably doesn't need a privacy fence. That probably is not reasonable. But again, you would need to look at all the actual, an attorney would have to look at all the actual facts to give you a true answer on that. If a ramp is installed by an owner on a common area, is the association responsible for its maintenance? Yes, the association would likely be responsible for like snow removal and things along those lines. In terms of if it starts to crack, you'd want to talk to your attorney about that for sure. But typically it's on common element, meaning all the other owners have access to it up to a certain point at least. So more than likely it's going to be the association's maintenance responsibility. Is age of class? So Ms. Lee, if you go back to a couple of the first slides, you'll see all the different protected classes. You have to, if I can scroll back to all of them. So in terms of age in and of itself being a protected class, no, it is not a protected class itself, but treating children differently, that would fall under familial status. So that is where age can come into play. So just age in and of itself is not a protected class. In an HOA, I manage, a tenant has requested a reasonable accommodation that the neighbor's garage door open be replaced with something quieter. The garage doors are LCs. They're not demanding the owner contact information for the unit that they don't live in. How do you recommend managing reasonable accommodations? I mean, I would have a hard time believing that there's a disability that would be affected by the noise of a garage door opener. So my guess is that there's no nexus. So I'd find it hard to believe that an accommodation would be needed for that. That's for you, Ms. Capelli. We have a no fence rule. Invisible fences are, a service animal is not allowed with an electric fence. They are asked for a regular fence and was denied. Is that reasonable? We have a no fence rule. Visible fences are presumably allowed. A service animal is not allowed with an electric fence. They asked for a regular fence and it was denied. Is that reasonable? I mean, again, if you're asking me to say if it's reasonable or not, I'd have to know a lot more facts and see what documentation they have regarding all of this. If there is a requirement for a service animal that it can't be with an electric fence, then I would say no, it's not reasonable to deny a regular fence in that situation. Any thoughts on pool handicap lifts at pool, required or not? So pool handicap lifts are required if you have an ADA pool. Again, most associations aren't subject to the ADA. So if you're not subject to it, more than likely there's no requirement for a pool lift. Okay, I think we're about 6 minutes over. I tried to get through. If I did not get to your questions, feel free to email me at jsmith@altitude.law, but I want to make sure I let all of you guys go. Thank you very much for attending. Please fill out the survey. Again, feel free to reach out to me if you have any questions, and I will either answer them or I'll forward them to one of the other people on my litigation staff so that they can answer them. I hope you guys enjoyed this. I know it was a lot of information. I apologize for talking so fast. But there was a bunch to get through. Have a great rest of your week and a good weekend. Thank you.